Good day, everyone. Welcome again to the continuation of the lectures on persons and family relations law. Our topic for today is absolute community of property. This is the default property regime for those who are entering marriage or for those who enter into the contract of marriage. Okay, so what is absolute community? Okay, absolute community of property, as I've said, is the default property regime, meaning that if you did not enter into any property regime or marriage settlement before you get married, okay, then automatically you will be governed by absolute community of property. So what is meant by absolute community of property? So it means that, okay, all the properties that you acquired while you were single, okay, the properties of the respective spouses before they entered into marriage will be placed in one basket, except for certain properties, which we will discuss later. Okay, these properties, the baseline is the date of the marriage. So all those properties that they were able to acquire, the spouses were able to acquire, will be placed in one basket and will become the community property. Okay, it is absolute because it does not distinguish. So meaning all the properties that you acquired before you got married and all the properties that you will acquire at the time of the marriage, from the time of the marriage and thereafter, okay, will form part of community property, save for certain exceptions, which we will discuss later. Okay, so Article 88 is very clear, okay, that absolute community of property starts at the time when the marriage is celebrated. That is the starting point. That is the baseline when the absolute community of property will take effect. Okay? You cannot provide a different date because Article 88 prohibits it. Any stipulation, expressed or implied, for the commencement of the community regime at any other time shall be void. So you cannot provide a date which is earlier than the date of the marriage. You cannot also provide for a date which is later than the date of the marriage. So the law fixes the time of commencement of the regime of absolute community of property at the time of the celebration of the marriage. Okay, now, the question is, after the marriage, okay, can you waive your property in favor of your wife or in favor of your husband? Article 89 tells us that no waiver of rights, interests, shares, and effects of the absolute community of property during the marriage can be made except in case of judicial separation of property. So, meaning that during the marriage, when you get married, you cannot waive the right to any of your properties in favor of your spouse, okay, except when there is judicial separation of property, which can either be voluntary or involuntary. But if in case it is involuntary, there must be a ground for the separation of property. Okay, when such waiver takes place, it shall appear in a public instrument. Okay, now Article 90 provides us the suppletory application of the provisions of co-ownership in cases which is not touched upon by this chapter, by the provisions of the Family Code on absolute community of property. Okay. Okay, the next thing that we have to learn. So we already know that it is the default property regime. We already know that the time of commencement of this property regime is at the time of the celebration of the marriage. Now we have to know what kind of properties does absolute community or does the community property consist. Okay, I have already said that all the properties which the respective spouses acquired before they entered into marriage will be placed in one basket and will be the community property. And at the time of the celebration of the marriage and thereafter, all the properties that they will acquire will also form part of the community property. Okay, now, what are the exceptions? Okay, the following shall be excluded from the community property. Number one, property acquired during the marriage by gratuitous title by either spouse. Remember the word during the marriage. So meaning, if for example, the one of the spouses uh, acquired by donation, simple donation, for example, a piece of land, okay, after he got married. Okay. Now, that property will remain to be the separate property of that spouse. It is not included in the basket of community property. Now, let us change the facts a little bit. If, for example, that property was donated before the spouse got married, meaning he was still single at the time when he received and accepted the donation. Will that form part of the community property? The answer is yes. Okay? So the property must have been acquired by gratuitous title during the marriage and not before. Okay? Because if it is before the marriage, that property will be placed in the community basket. If it is after the marriage, acquired by gratuitous title, it will not form part, it will remain the separate property of the spouses. So what if that property, the land, is earning rentals, for example? So it may be considered as fruits of the land. Will that form part of the community property? The answer is no. It will remain to be the separate property of that spouse. Okay? Second, property for personal and exclusive use of either spouse. However, jewelry shall form part of the community property. Okay. So, if the property is for the personal and exclusive use of either spouse, that will remain to be the separate property of that spouse. Okay. Except jewelry. Why? There was one question that I received from the class. Why was jewelry excluded from, meaning excluded from the separate property of the spouse? Why? Because jewelry is primarily acquired not for ornamentation, but for investment. Okay? So the jewelry shall form part of the community property. Okay. 3, property acquired before the marriage by either spouse who has legitimate descendants by a former marriage and the fruits as well as the income thereof. Okay, so if you have a previous marriage, okay, the general rule that all the properties that you acquired before you got married will be placed in the basket of community property will not apply to you. Why? Because all the properties that were acquired, okay, by that spouse who has a previous marriage will remain to be his separate property. Okay? Provided that that spouse is legitimately married before. Okay? Before the present marriage. So these 3 properties are considered as exclusive property of the spouse concerned. They are not placed in the community basket. Okay? There is also a presumption that all the properties that the spouses acquire during the marriage will belong to the community property. And whoever alleges that that is the exclusive property of either spouse has the burden of proof. So for example, if you acquired a property, for example, a land through succession after you got married. So you acquired it at the time when you were already married. Okay, now, of course, the spouse concerned will say that that is not part of community property, that it's a separate property or my exclusive property. Now, that spouse who is alleging that it is a separate or exclusive property has the burden of proving that it is one of the exceptions mentioned in Article 92, that it is a property acquired by gratuitous title during the marriage. So if that is proved, then it will be excluded from the community basket. But unless there is proof that is presented to that effect, the presumption remains that it forms part of the community property. Okay? Uh, Okay, so we already know the default community property regime, the time when it commences, the composition of the community property, the exclusions from the community property. Now, we have to know what are the charges upon the community property. What can you charge on community property? Of course, support of the family. Okay? When you say family, support of the spouses, their common children, legitimate children of either spouse. Okay? The everyday expenses of these people, okay, can be charged to the community property. Okay? Debts. Okay? All debts and obligations contracted during the marriage by the administrator spouse for the benefit of the community or both spouses or by one spouse with the consent of the other. So the debts, okay, can also be charged upon the community property. How about debts which were contracted without the consent of the other? Can you charge it upon community property? The answer is yes, provided that the proceeds of the debt or the loan has redounded to the benefit of the family. Okay? How about government impositions such as taxes, liens, charges, and expenses upon the community property? For example, you have a land which is part of the community property and there are real property taxes. Okay, can you charge it upon community property? The answer is yes. Okay, uh, government impositions such as taxes, liens, charges, and expenses can be made or can be charged upon community property. Taxes and expenses for preservation made during the marriage upon the separate property of either spouse used by the family. So if you have an exclusive property, such as, for example, you inherited a land from your parents and you use it as a vacation home. Okay? Can you charge the, let us say, real property taxes of that land to the community property? The answer is yes, because if it is used by the family. But if it is not used by the family, or if it is being rented, for example, you must charge the real property taxes of that to your separate money. Okay? Expenses to enable either spouse to commence or complete a professional or vocational course or other activities for self-improvement. That can also be a part of support because support comprises of everything, not only food, clothing, medical expense. It also includes education, transportation. Okay? Number 7, antenuptial debts of either spouse insofar as they have redounded to the benefit of the family. So if you contracted your debt before you got married, but the proceeds thereof were used for the benefit of the family, then you can charge the payment thereof to the community property. Okay, the value of what is donated or promised by both spouses in favor of their common children for the purpose of commencing or completing a professional or vocational course. So that is also part of support for education. So you can charge it to the community property. Antenuptial deaths of either spouse, the support of illegitimate children, and liabilities incurred by reason of a crime or quasi-delict in case of absence or insufficiency of the exclusive property of the debtor's spouse. Remember that when it comes to illegitimate children, okay, the support of which will come primarily from the separate property of the spouse concerned. However, if the separate property or the income thereof is not sufficient to provide or to fill in the support of the illegitimate children, you can charge it also against community property subject to deduction later with respect to the share of that spouse concerned upon liquidation. Okay? Expenses of litigation between the spouses unless the suit is found to be groundless. So if one of the spouses figured into a lawsuit, okay, the expenses for attorney's fees can be charged upon community property. Okay. How about with respect to gambling losses and winnings in lottery or any other forms of gambling? How can they be treated? Can winnings in gambling be considered part of community property? Can losses be also be charged to community property? Article 95 tells us that whatever may be lost during the marriage in any game of chance, betting, sweepstakes, or any other kind of gambling, whether permitted or prohibited by law, shall be borne by the loser and shall not be charged to the community, but any winning shall form part of the community property. So, winnings, they form part of the community property, but losses, you cannot charge it to the community property. You have to bear it through your own separate property. Okay. Okay, let us go to administration, disposition, and encumbrance of community property. Okay, who will administer the community property? Is it the husband or the wife? The answer is they will administer the community property jointly. Okay, so it is joint administration. What if there is a disagreement? Article 96 tells us that it is the husband's decision which will prevail, of course, subject to the recourse of the wife to the court if he feels that the husband is not justified or has abused his authority in making that decision. Okay, which must be filed within 5 years from the date of the contract implementing the said decision. Okay, what if one of the spouse is not capacitated to administer? Then the other spouse may assume sole power of administration. However, we must distinguish the powers of administration from the powers of disposition. Okay, the power is only limited to the management of the community property. The spouse who is empowered to administer or manage the community property is not authorized by himself to dispose or encumber any community property. Okay, in order to do so, you must have the consent of both spouses, or if the other spouse is incapacitated, the administrator spouse has to go to court to be equipped or to apply for an authority to dispose or encumber a community property. Article 97 tells us that either spouse may dispose by will of his or her interest in the community property. So the power of disposal, the prohibition on the power of disposal of either spouse is limited only to inter vivos disposals, meaning he cannot dispose on his own any community property while he is still living. But when he is already dead, okay, he can dispose by will, okay, of his or her interest in the community property. That is not prohibited. Okay. There is also a prohibition on the donation of any community property without the consent of the other spouse. Okay, except with respect to moderate donations for charity or on occasions of family rejoicing or family distress. Okay, so you are prohibited. One of the spouses cannot dispose either by sale, any kind of disposition, sale, donation, assignment, okay, any community property, unless, of course, both of them gives their consent, okay, except with respect to donations on family rejoicing. For example, it's Christmas. So, there is a donation, for example, of, let us say, jewelry, a ring, for example, to the spouse or to the children, okay, or occasions of family distress. There is death in the family. So, there is, for example, a donation, okay, or moderate donations to charity. That is not prohibited by law. Okay, we now go to the cases concerning absolute community. Okay, the first case is Nobleza versus Nuega. Okay, this is a case when they were still single. Okay, the parties bought a residential lot. The lot was titled in the name of Rogelio. Okay, um, Shirley at that time was working abroad, but she contributed to the purchase of the lot. However, considering that she was not present at the time when the title was issued, so it was issued only under the name of Rogelio. However, after they got married, okay, Shirley discovered that Rogelio had an extramarital affair. So he filed a case for legal separation and liquidation of property. However, Rogelio sold the property without Shirley's consent because the title was issued only in the name of Rogelio. So he was able to sell it without Shirley's consent. Now, the issue is the sale of the property valid? Remember, we discussed earlier that with respect to sales or disposition of community property, you have to have the consent of both spouses. Okay? Since the subject property does not fall within any of the exclusions under Article 92, it forms part of the community property. Regardless of their contribution, and despite the fact that it is only titled in Rogelio's name, that property is owned jointly by the spouses. Okay? The Supreme Court further held that Shirley could not be held accountable to the petitioner for the reimbursement of her payment for the purchase of the subject property. There being no evidence that the amount received by Rogelio redounded to the benefit of the family, respondent cannot be made to reimburse the same. Okay? Santos versus Santos. Okay, this is a relatively new case. It is a 2021 case. Okay, so we have here a case involving Maria, who was then 16 years old when she first met Jose. At that time, Jose then was married to Josefa. Okay, so there was no romantic relationship between them because both of them have their respective spouses. Okay, now, Dominador died in 1990, the husband of Maria. Now, Jose allegedly had 8 children with Josefa. After the wife of Jose died, he courted Maria. So Jose and Maria eventually got married against the wishes of Jose's children. Now, of the 6,000 square meter property given to Jose, he sold or donated segregated portions of the property to his children. Now, that property, subject of this case, is a disturbance compensation of tenant. So, Jose received this as a disturbance compensation. Now, Jose executed a kasulatan ng pagkakaloob-pala gratuitously transferring in favor of Maria a portion, 805 square meter portion of the said property. Now, Maria opposed, there is, Jose died without a will. Now, after he passed away, the surviving children asked Maria to divide the 694 square meter lot into 9 equal portions for distribution to Jose's children and grandchildren of the first marriage. So naturally, Maria opposed, insisting that she is the sole owner of the subject property by virtue of the kasulatan ng pagkakaloob-pala, so the deed of donation. Now, the issue is whether Maria became the sole owner of the property covered by the deed of donation executed by Jose before his death. Okay. Donations between spouses during the marriage are prohibited. The donation of the property Jose made in favor of Maria through the kasulatan ng pagkakaloob-pala prior to his death is null and void. So accordingly, Maria cannot claim to be the sole owner of the subject property based on the void donation. So whether the subject property forms part of the absolute community of property of Jose and Maria. For marriages that took place after the effectivity of the family code, the absolute community is the default property regime. Since the marriage between Maria and Jose took place in 2002, the property regime governing their marriage is the absolute community of property. It was already established that the subject property was acquired by Jose by onerous title, okay, because it was a disturbance compensation. Thus, it shall form part of the community property of Jose and Maria. Remember the exclusions under Article 92? One of the exclusions is that property acquired during the marriage by gratuitous title. In this case, it is not a gratuitous title but an onerous one. Why? Because it is a disturbance compensation. Since it was acquired during the marriage, it becomes part of the community property. It is not one of the exclusions. Okay, so that is what that case tells us. Okay. Tazon versus Quintas, the next case. So this is a case involving a complaint for declaration of nullity, annulment of contracts of lease executed by a husband without the consent of his wife. Remember that leases are encumbrances. So it is not part of administration or management, which can be exercised by the administrator's spouse. Okay, so it has to have the consent of both spouses, especially if the lease is more than a year. Okay, so Dennis is the registered owner of 2 parcels of land. Okay, it was occupied by 2 companies owned by Tazon and his family. So Tazon, Worldweiser, and Gerson raised the defense that the contracts were validly executed even without the consent of Fuentes. Okay, Fuentes no longer resided in the conjugal home and failed to participate in the administration of their common properties. However, on the other hand, the wife emphasized that the law clearly requires written consent for conveyances involving common property. Her knowledge that the lessees were occupying the subject property did not amount to knowledge nor implied consent to the transactions, given that she is already estranged from his husband, and since 2006, she had been living separately from him. Okay, Article 124 protects the community property from unlawful dissipation by any of the spouses, which could prejudice the family. So the procedure before a spouse could convey common property without the written consent of the other spouse in case of the latter's incapacity or inability to participate in administration is laid out in Article 124. So it is compelling that there was no showing that Tuason obtained the authority of the court pursuant to the said provision, considering that the transaction involves a conveyance or encumbrance of a common property. So Tuason tells us that before you can encumber or mortgage a property which belongs to community property, you have to get the consent of your spouse, or if you are not living with that spouse, you're estranged from him or from her, you have to at least get the consent of the court for the encumbrance because this is not part of administration. Okay. So we already know the property regime of absolute community, what consists of it, the time of its commencement, what are the charges that you can make against the same, who has the power to administer the same, and what are the rules regarding encumbrance or disposition of community property. We now go to the end, which is the dissolution of community property. How does it terminate? How does community, absolute community of property regime ends or terminates? Okay, the Article 99 provides for the grounds for the termination of absolute community. Number one is death of either spouse. Why? Because death terminates the marriage. There is no marriage, there is no need for a property regime that will govern the marriage. Okay? When there is a decree of legal separation. So when there is a decree of legal separation, there is separation from bed and board. So naturally, if the spouses are no longer living together, there is no more need also for their property to be mixed or to be placed in one basket. Okay, when the marriage is annulled or declared void. Okay, if it is declared void, uh, or annulled, okay, their marriage will be, their property relations will be either governed by Article 147 or 148, depending on the ground or the impediment that may or may not exist on either spouse. And last, in case of judicial separation of property during the marriage. Because if there is already a decree from the court stating that they will be governed by separation of property, then naturally that property, separation of property regime takes over, okay, the absolute community property regime. Okay. How about when the spouses are separated in fact? Okay, does separation in fact terminate absolute community? Well, Article 100 is very explicit when it stated that the separation in fact between the spouses shall not affect the regime of absolute community except for the following. The spouse who leaves the conjugal home or refuses to live therein without just cause shall not have the right to be supported. Okay? When the consent of one spouse to any transaction is required by law, judicial authorization shall be obtained in a summary proceeding, such as the last case that we discussed, Tuason. So if you need a consent to the disposal or to the encumbrance of any community property, you have to get the consent of the court if you cannot get the consent of your spouse. Okay? In the absence of sufficient community property, the separate property of both spouses shall be solidarily liable for the support of the family. Okay? So it also provides for the support of the family in case there is insufficiency of the separate property of either spouse. Okay? Article 101, if a spouse without just cause abandons the other or fails to comply with his obligations to the family, the aggrieved spouse may petition the court for receivership, for judicial separation of property, or for authority to be the sole administrator of the absolute community. When is a spouse deemed to have abandoned the other spouse? If he or she has left the conjugal dwelling without any intention of returning for a period of 3 months, okay? Or has failed within the same period to give any information as to his whereabouts. So there is already a presumption that he has already abandoned the conjugal dwelling. In which case, if the present spouse has a need to dispose, for example, of a certain property in order to support the family, he can, under Article 101, file a petition in court for receivership, for judicial separation of property, or for authority to be the sole administrator of the community property. Okay, we have the case of Muller versus Muller. So in this case, we have spouses Elena and Helmut who were married in Germany. They decided to move and reside permanently in the Philippines. However, by this time, respondent inherited the house in Germany from his parents, which he sold and used the proceeds for the purchase of a parcel of land in Antipolo. So the German spouse, the husband, okay, inherited a parcel of a house in Germany. Now he sold the house in Germany and used it to purchase a property in the Philippines. Okay, the property was registered in the name of his wife. Why? Because there is a constitutional prohibition against aliens acquiring real properties in the Philippines. That is the reason why it was named in the name of Elena, the wife. Okay. The spouses, however, eventually separated. Now, the respondent filed a petition for separation of property, okay, which terminated the regime of absolute community. Now, with respect to the Antipolo property, the court held that it was acquired using the paraphernal funds or the exclusive property of the German husband. However, it ruled that the respondent cannot recover his funds because the property was purchased in violation of a provision in the Constitution prohibiting aliens from acquiring real properties in the Philippines. Uh, the respondent's purpose for filing an action for separation of properties is to obtain exclusive possession, control, and disposition of the Antipolo property. Okay, now the respondent is claiming that he is not praying for the transfer of ownership, but only for reimbursement because he acknowledged the fact that he cannot own real properties in the Philippines. He is just saying that his wife should reimburse him for the amount for which he used to purchase the said property because it is his exclusive property. It was acquired by through gratuitous title at the time when he was already married to Elena. Okay? Now, the issue is whether the respondent is entitled to reimbursement of the funds used for the acquisition of the Antipolo property. So in this case, the respondent cannot seek reimbursement on the ground of equity, where it is clear that he willingly and knowingly bought the property despite the constitutional prohibition. To allow reimbursement would in effect permit respondent to enjoy the said property which he is not allowed to own. So that is the ruling of the Supreme Court because he knew, the German national knew that he is disqualified from acquiring properties within the Philippines. And yet, despite knowledge of the said prohibition, he still proceeded on using his paraphernal funds to purchase real properties in the Philippines. So he is, in effect, estopped from claiming reimbursement. Okay. So when the absolute community terminates, there is a need for liquidation of the community property. How do you liquidate community property? Now, the procedure for liquidation is the same in all property regimes, whether it is community, whether it is absolute community or relative community, such as conjugal partnership of gains, it is the same. First, you have to make an inventory. So you list all of the properties which belong to the community, all of the properties which belong separate to the spouses. Now, debts and obligations you deduct from the assets of the community property. Okay? In case the assets are not sufficient to cover all the debts, that is only the time when you can charge it to the separate property of the spouses. Now, if there is still a remainder or a net asset, okay, it will be divided equally between the spouses. Okay? If there is also a remainder of the exclusive properties of each spouse, then shall be delivered to them respectively. Okay? Now, the presumptive legitimes of the common children shall also be delivered to them. Okay, how about the conjugal dwelling who will be entitled to it? It will be awarded to the spouse with whom the majority of the common children choose to remain. Okay, what if they are equal? Okay, in case the court will decide taking into account the best interest of the child. Okay, so Kaburnay versus Siso. Okay, so in this case, Chodulo sold a parcel of land to Apolinario on installment basis. At the time of the sale, Chodulo's first wife, Perpetua, died in 1989, and he entered into a subsequent marriage in 1992 to Perla. So we are talking here of two marriages. Perla did not give her consent to the sale. Chodulo passed away before the balance of the price could be paid. Okay, upon Apollinario's death, his heirs tried to pay the balance on the purchase price, but Jesus rejected the payment. Instead, they executed an extrajudicial settlement of estate of Chodulo and his wife Perpetua, and the same included the subject property. Okay, so the petitioners invoke Article 103 of the Family Code, which provides that should the surviving spouse contract a subsequent marriage without liquidation of the prior marriage, then the mandatory regime of complete separation of property will govern the property relations of the subsequent marriage. As such, petitioners assert that Chodulo could validly dispose of his share in the property acquired during his first marriage without need to obtain the consent of the second spouse. Okay, but the property regime of Chodulo and Perpetua was conjugal partnership of gains since they were married under the civil code. Okay, when Perpetua died in 1989, the conjugal partnership between her and Chodulo was terminated. With Perpetua's death, the liquidation of the conjugal partnership between her and Chodulo should have been made. However, this was not done. Okay, the surviving spouse and the heirs of the deceased spouse do not liquidate the conjugal properties and they keep them undivided. In such a case, a co-ownership is deemed established for the management, control, and enjoyment of the common property between the surviving spouse and their common children. Okay, as far as the conjugal partnership property of Chodulo and Perpetua, one half undivided interest therein pertain to Chodulo as he shared and the other half pertains to their legal heirs. Thus, the subject property became co-owned between Chodolo and the heirs of Perpetua. Okay. Article 30 provides two consequences if no liquidation is effected within the 1-year period from the death of one spouse. Any disposition or encumbrance involving the conjugal partnership shall be void, and should the surviving spouse contract a subsequent marriage, a mandatory regime of complete separation of property will govern the property relations of the subsequent marriage. So what happens now to the sale? Is it valid or not? Okay, the Supreme Court said it is that undivided interest that the surviving spouse can freely dispose of without the need of the other co-owner's consent. As to the undivided share of the other co-owners, the disposition by the surviving spouse is not valid, and the same holds true with respect to dispositions made by the surviving spouse after the effectivity of the family code. The disposition by the surviving spouse, despite non-observance of the requirement on liquidation within 1 year from the death of the spouse, is recognized as one that is not totally void. The disposition is recognized as valid to the extent of the undivided share of the disposing surviving spouse. So with respect to Chodolo's shares, okay, on that property, which is 1/2, okay, of the property, that is valid. But with respect to the disposition of the other half, which should have belonged to the legal heirs of Perpetua, okay, that is void. So how about Perla, the second wife? Was her consent needed? That is another issue. Okay. Mandatory regime of complete separation of property shall govern the property relations of the subsequent marriage. So given that complete separation of property governed the subsequent marriage, and Perla, the 9/16 undivided share or interest in the subject property of Chodolo belonged to him and remained with him as his separate property when he married Perla. Thus, he could have disposed of this without need of consent from Perla. So the sale by Chodolo of the subject property to Apolinario was not necessarily or totally void, for his right as a co-owner to the extent of 9/16 was effectively transferred, making the buyer a co-owner of the subject property to that extent and a trustee for the benefit of Chodolo's co-heirs, his 7 children, with respect to the portion which was not validly sold. Okay? We have here the last case, Sapanta versus Rustan. Okay. Nida was an employee of Rustan's Commercial Corporations, which owns a chain of department stores selling gift certificates. Okay. Nilda was working as a credit and collection manager. Now, German is being sued in his capacity as Nilda's husband. Now, due to the anomalies in the sale of the gift checks, Rustans filed a complaint for payment of sum of money and damages against Nilda and her husband, German. Now, can you charge the liabilities, okay, that Nilda incurred in the civil aspect of the criminal case to the community property? Okay. Both the community property and the conjugal partnership regime impose similar restrictions with respect to obligations contracted by either spouse without the consent of the other. To bind the absolute community, actual benefit to the family must be proved. In this case, German cannot escape the joint and solidary liability to pay the obligation arising from Nilda's fraudulent scheme in pocketing the proceeds from the sale of the gift checks. Without any evidence to the contrary, it is presumed that the proceeds of the loan redounded to the benefit of their family. Hence, the community property may be held liable. So, the requirement in order to hold the community property liable is that if the proceeds thereof redounded to the benefit of the family. Okay, so that is the end of today's presentation. Thank you for listening.